Welcome to the Nimbus Consulting Group's Overview of State Mandated Cost, also known as SB 90 or State Mandate Reimbursement. The state of California is unique in the fact that it has a program that will help local agencies get reimbursed. This comes through California State Law, Government Code Section 17500 through 17616. It provides for the reimbursement of costs incurred by local agencies for costs mandated by the state. But why does California have this law? In 1972, the state legislature passes the Property Tax Relief Act, Senate Bill 90, also known as SB 90, which limits the ability of local agencies and school districts to levy taxes. To offset these limitations, the state declares its intent to reimburse local agencies for any increased costs resulting from a new program or higher level of service. These restrictions were furthered by the passage of Proposition 13 and Proposition 4. We'll discuss Proposition 1A a little later in this presentation. Proposition 4 adds Article 13b, Section 6 to the California State Constitution. This passage reads, whenever the legislature or any state agency mandates a new program or higher level of service on any local government, the state shall provide a subvention of funds to reimburse that local government for the cost of the program or increased level of service. Not all laws are considered to be reimbursable mandates. So what is a mandate? Well, it's a law, statute, regulation, or executive order that can impose unique requirements on local government, may implement state policy or law. It could shift funding responsibility from state to local agencies. It can add a new program or require a higher level of service on an existing program. Now that we know what could be a mandate, let's discuss what is not a mandate, or the exceptions to the subvention of funds. Well, if a mandate is requested by a local agency, or the legislation is defining a new crime or changing an existing definition of a crime, if it mandates an executive order or regulation enacted prior to January 1st of 1975, if it is not unique to local government, if it is a proposition adopted by the voters, or if it's mandated by federal law and not just state law, or if it has self-financing authority and you are able to charge a fee for that service, these are all not considered to be reimbursable mandates. How does a local agency go about obtaining reimbursement through state-mandated cost? Well, a local agency must file a claim with the Office of the State Controller in order to get reimbursed. If you do not file a claim, you will not get reimbursed. Reimbursement is not automatic. A reimbursement claim is defined in Government Code Section 17522 as any claim filed with the Office of the State Controller by a local agency for reimbursement of costs incurred. Claims are filed based off of the fiscal year and must make a minimum of at least $1,000 in order for the claim to be accepted by the State Controller's Office. There are 3 different types of claims that can be filed. Initial reimbursement claims are claims for new programs that often go back multiple years. These claims are due 120 days after the initial claiming instructions are released through the Office of the State Controller. Annual or ongoing reimbursement claims are due every February 15th for costs incurred for the prior fiscal year. For example, February 15, 2010 is the deadline to submit claims for cost for fiscal year 08-09. Amended claims amends a claim that has already been submitted to the State Controller's Office. You must file this amendment within 1 year of the initial claiming deadline in order for the state to accept this new cost. There are currently approximately 51 eligible state-mandated reimbursement programs. These programs can be viewed at the State Controller's website at www.sco.ca.gov. Why should a local agency bother with filing these reimbursable claims? Well, again, reimbursement for state-mandated costs is not automatic. If you do not file a reimbursable claim, you will not get paid. As a local agency, you've already incurred the cost to perform these mandated activities. The state is obligated to pay for these programs. In the State Budget Act of fiscal year 2009-10, the state appropriated over $79 million for reimbursement of these programs. Most of that has already been disbursed, with the remaining amount due by June 1st of 2010. This reimbursement comes back to your agency as general fund revenue. It is at your discretion as to how to use this revenue. There is also a program available to help pay for your staff time, consultant time, or consultant fees to prepare the state-mandated cost claims. Proposition 1A of 2004 amended Article 13B, Section 6 of the California State Constitution. This requires that unless the legislature appropriates the full payable amount in a fiscal year for a mandate, the operation of the mandate shall be suspended for that fiscal year. What that means is when a mandate is suspended, it makes those activities identified in that mandate optional to perform for that fiscal year. Before discontinuing any service, it's always advisable that you discuss this with your counsel. There is a special carve-out or an exception to payment of claims under Proposition 1A. Full payment is not applicable to a requirement to provide or recognize any procedural or substantive protection, right, benefit, or employment status of any local government employee or retiree, or of any local government employee organization that arises from, affects, or directly relates to future, current, or past local government employment, and that constitutes a mandate subject to this section. What that means, if the state cannot appropriate full payment for a program that deals with somebody's labor rights or benefits, then the state can opt, instead of suspending that program, just to defer the payment. That payment will come at a future date. An example of this is the Peace Officer Procedural Bill of Rights. Currently, under Government Code Section 17561, subsection D, the State Controller will pay any eligible claim by October 15th or 60 days after the date the appropriation for the claim is effective, whichever is later. The effective date always goes hand in hand with the effective date of that year's state budget. Funds are appropriated based off of a State Controller's report that the legislature receives called AB 3000. That's a report that states exactly how much is still pending in payments for state-mandated costs. This concludes the Nimbus Consulting Group's overview of state-mandated cost. For more information or questions, contact us at www.nimbusconsultinggroup.com or contact us at our number listed below.